How you doing? My name is William. Welcome to More Money, No Problems, where where we'll tell you the things that your financial advisor won't. Today, I'm here to welcome attorney Natalie Green. How are you?
I'm doing great. Thanks so much for having me today.
Excellent, excellent. Well, thank you so much for coming down. What I want to do today was discuss with you estate planning. Attorney Green has been an estate planner for how many years?
I've been an attorney for 21 years, estate planning probably for the last 11 of those 21 years, yeah.
Okay, and what brought you into estate planning?
Estate planning it's been a migration of different practice areas. I started out with divorce work, family law, collections. I kind of bounced around different practice areas, but after doing divorce for a while, it wasn't really my cup of tea. I really liked the people, but I didn't enjoy dealing with opposing counsel. It just got to be very kind of toxic type of practice area. But when I got into estate planning, that was more about watching my clients sort of progress, because as I had clients that got divorced, after they got divorced, they needed wills revised. And so they would come back to me and say, I need to get my will changed now that I'm not married to this other person. Because, when you get divorced, that, your will is there, but it nullifies it in a lot of states. So I got into writing wills, and then from there started talking about, what happens when someone has a will that only covers part of the issues. People don't realize that. So then I got into learning about trusts and holistic planning and got my insurance license because I wanted to know about not just the legal structure of doing an estate plan, but then the financial side of it. And then that's how I met different financial advisors. And then that's how, I got into your orbit. And, it's just been something that I really enjoy, the technical side of it.
Excellent, excellent. And can you explain to us what the difference between a will and a trust is? Or do they coincide with each other?
When I do an estate plan for a client, I want a will to complement a trust. So the key difference between a will and a trust, a will think of a will kind of like your final love letter to your family. And a will is going to be a list of instructions of what you want to have happen after your passing, to say, what do I want my assets to do? Where do I want them to go? Who do I want them to go to? And so you can dictate that, but that is only going to take effect as of when you pass away. So there are a lot of things that happen in our life from the day we make our will to the day that we pass away.
Okay.
And so the will is only going to be triggered as of that event, your passing. So why doesn't it do anything else? Well, it really can't, because it's only a contract, sort of like an expectancy contract. It just doesn't do anything until then. Whereas a trust, we call it a trust agreement because it's legally a document that you are entering into agreement with essentially yourself and your beneficiaries. So with a trust, you have multiple roles or people involved. You've got the grantor, and that's the person who's making the trust. So that would be you. Let's use you as a scenario.
Okay.
So when you set up your trust, you're going to be the grantor, you and your wife. You two will be the ones putting your assets into that trust. So you're the grantors, you're granting that trust these assets. But you're also the beneficiary if we're using, say, a revocable trust. So you're the beneficiary because you're going to use those assets during your lifetime. Then we're going to look at, okay, so who is going to be the trustee? All trusts have to have a trustee who will essentially manage the trust and be in charge of the trust, have powers over those assets. Because once the grantor transfers assets to the trust, then the trust owns them. So legal title for, say, your house is going to be transferred by the deed from your name and your wife's name into the name of the trustee. So you guys will then be trustees. So you get to play three roles once you establish your own, trust during your life. So when we set those up for estate planning purposes, you then become the owner of your house still, but in the capacity as a trustee. So then what does that mean? It seems like a lot of names and a lot of words, but essentially you're still in control of your assets when you have a revocable trust. There's lots of different types of trusts, but the most common ones for people that just want to have a plan that avoids going to probate after someone passes away, they're going to have a revocable trust. So you still have control over it. You still get to make modifications to it. And a lot of times, what you can do is you can then dictate how those assets are transferred and managed after you go. So, you both are going to pass away at the same time, God forbid. But what you can control are things that happen afterwards that a lot of people don't get to control when you have a will. Because if one of you is going to pass away, the other person's still going to own those assets. But what if you go first and your wife passes away? You have children. You have a beautiful wife. She's going to potentially marry somebody else. What if she does? If she marries someone else, they have legal rights as a spouse to assets that she might own.
Mm-hmm.
So if she only had a will, which now she had a will when she was with you, when you pass away, she no longer has you as her spouse. She has somebody else. So they have a couple of things that they can do that could really just swipe in and take things that would normally go to your kids.
Okay, so what you're saying is the big thing is to be able to control it from the grave.
Right.
So, because I do hear a lot of people say, you should put your house in the trust, put all your assets. Now, what about bank accounts and things like that? Should that also go in the trust?
You can put your bank accounts in the trust. You can actually operate financially completely within your trust. A lot of people don't do it though, just for convenience purposes. They'll just set up their trust to hold mainly their hard assets like a house.
Okay.
And so they'll hold their real estate in there because most other assets can transfer to your family members by virtue of, the bank account itself. So when you go up to set up a bank account, they're going to ask you, well, who are your beneficiaries?
Okay.
Now, when we set up an estate plan, I usually tell my clients, I want you to change those beneficiaries to go from the bank account to the human being, from the bank account to the trust. And the reason for that is maybe you have, FDIC limitations. You have $250,000 in multiple bank accounts. Do you really want that cash going straight to your kids? And if you don't want it going straight to your kids, or you want to gate that money to say, all right, well, all this money is going to go into the trust in general, and they only get the money under certain circumstances. They need to be using it for a business venture. They need to use it for education. They need to use it for certain things, or I want to hold it in a trust so that their spouses can't get into it unless there's certain things, There are ways to control it and limit access to it by using, certain types of trustees or making co-trustees so that they have to act unanimously. So there's a lot of different ways that I kind of get in there and kind of poke at the parents and say, so really tell me a little bit about your kids because, you have two boys are very different. Mm-hmm. And so when your children are different, you might not want to give them money in the same way, or you might have a child who's special needs that needs to qualify for Medicaid when you're gone.
Okay, yeah.
Totally different way to need to give them money too. So
essentially, if your kids get married and you have the house or you have an estate, and you say to your kids, you know something, we're leaving. You can have the house, and that son or daughter gets married. Mm-hmm. Then they find out 5 years down the line, something. The spouse says, "I'm not in love anymore." Are you saying that spouse would be entitled to half of that house if it's not in the trust, if it's owned by, if we just give it to the child?
Well, in many states, an inherited asset is not on the table to be divided and given to the person who didn't inherit it. So, for example, you and your wife passed, you leave it to maybe your oldest child. And when he receives it, if it's titled to him from your estate, but not in a trust, then it belongs to him. Even though it belongs to him, and no judge in Georgia can force him to give it to her, there is a contribution that she's making during the marriage by cleaning it, by cutting the grass. And these are just generic everyday things. She's not even really improving it, but she's helping him pay other bills, even though he's paying just the taxes on it. So the property is appreciating in value. So because of all those things, when they do get a divorce later, she can ask for a portion of the increase in equity. Yeah, the equity increase. So then she could go, oh, well, when your parents passed away, the house is worth $500, But because we were married all this time, the market took a huge swing upward. Now the house is worth $750, so I need $125,000 out of that house. But Judge, I thought that she can't have anything that I inherited. That's true. But she can, that's transferring ownership. She could certainly have equity transferred elsewhere. So yeah, 401k that you got also from your dad, you might have to pony some money over there to balance the equities of the marriage. Or he might have money of his own
Okay.
that
So
he needs to give her.
and will a trust protect that?
A trust can protect that in several different ways because it will be owned by the trust, not him.
Oh, okay.
So you never transfer the ownership of the property out of the trust.
Oh, okay.
So he never owns it. He gets the pleasure of living in it. The trustee, I would say if you have two kids, I always like to tell my clients, make the two kids joint trustees of each other's trust so that, let's say he does get the house and he says, all right, well, let's sell the house. All right, we're going to sell that house. Now there's all this cash money. She says, I don't want to live in your parents' old house. I'm in a nice new shiny house. Well, we'll ask the trustee. We'll ask my brother. We'll liquidate this house. The cash goes back into the trust. And then she says, well, good. Now we get to buy a house and it can go in my name. That's not the way it works, honey. Then the money can then be used to purchase another house in the name of the trust. It can be a house that she chooses and helps pick out. But still, it's going to be owned by the trust. It doesn't.
Because the money came out of the trust.
The trust is still going to
own it.
Go and purchase
okay.
it, and then at that point, the trust is still going to own it.
Oh,
She won't
wow.
get to have any ownership. They still get to have a house. Let's say there's money that needs to be. Maybe they want to buy a house in their name together, and he's like, "Well, we have to borrow money." At that point, you do have to mix some personal money with the trust money. At that point, she's like, "Well, we have to get a loan." All right, well, we need to get a loan, but we need to borrow some money from your trust for the down payment. Or go get some money from the trust for the down payment. Okay, I'll ask my brother. He's my co-trustee. Go to the brother. I'm not just going to give you money if you're going to own it with her. So guess what? Now we need to get a promissory note from the trust. The trust needs to issue a promissory note that puts both of them in debt to that trust. So if she wants to walk, she wants to leave, she can leave. But when we go to a divorce setting, and this is where my divorce background kind of kicks in, and I'm like, oh, no. We're going to make sure this is airtight. You want to make sure that when they look at assets, liabilities, where are we balancing this out? That house doesn't just become, well, there's plenty of equity in that. He's going to get to keep it, so she gets to have all of her debt paid for in the divorce. No. That house has debt on it that both of you owe. So that gets paid back to the trust if they have to liquidate the house in the divorce.
Oh, wow.
You don't want to impoverish your trust. You don't want to keep giving money out of the trust. If he's going to take money out of the trust to buy something, that's fine. But the trust is going to be made whole.
Now, I know a lot of times they say that a loan isn't necessarily a loan if it doesn't have interest paid.
True.
So does a trust charge interest on those loans?
Yes,
and
you should.
And if those, loans, is the interest paid back monthly to the trust, or how would that work?
That's something that they'll need to get some advice on when they actually create it, because otherwise it's a straw man, and that is something that the judge is going to look at in the divorce setting and go, well, you guys haven't treated it like a loan.
Exactly.
And if you haven't treated it like a loan, it's not really a loan.
Exactly, yes.
Even though it's recorded, you can record it, a security deed against it, and it's a lien on the house. But the treatment of that is based on, when you want to transfer and sell the house. The way they look at it in the divorce setting is going to be, well, you never treated it like a loan. Even though you papered it like a loan, we're not going to treat it like a loan in the way that you're dividing it up in a divorce setting.
Exactly.
Because at that point, we're going by, the way you did things. Just the same way you would say, well, he always paid my bills. I never had to pay any bills. The alimony kind of arguments people make.
Okay.
So that's how the trust can ensure that debt will be paid by charging some amount of interest, and that interest, it can be an interest-only loan. It doesn't have to have, you have a balloon payment way out in the future, but it doesn't have to have, it can't be zero interest.
It has to meet the parameters actual loan
Yeah, there are IRS
rules.
regulations on what it would truly be as a loan.
Okay, and I also have a lot of people ask me when it comes to life insurance, should I put my policy into the trust? Um, and what are your feelings about that?
You can certainly do that because you can actually insure the trustees. Let's say you had a child who was a special needs child and the parents are the trustees, but you might have a sibling who's the caretaker of that child. You want insurance policies on all three of them because as each of those people passes away, they're a caretaker of that special needs person. The special needs person can't earn income. They can never earn income or they're going to lose their Social Security benefits and they literally can't work. So the way to keep replenishing money to care for them and to be able to afford a caregiver if they all keep passing away is to have life insurance policies.
Okay.
So if you have a life insurance policy that's going to keep putting money back in, insure everybody in the family that could potentially be a caregiver to that special needs person. So still same thing in a family that doesn't have a special needs member. You want to have the trustees and the family members insured. I've got a client, they did a dynasty trust. And there are incentive funds and foundation type funds in the trust so that anyone in the family who obtains an insurance policy, if they name the trust a beneficiary, they can take a share in some of the proceeds every time someone that is in that pool of or class of family members. When one of them dies, everybody gets a payout because that person's money goes into that pool.
Oh, okay.
So they all always get like a regular payout as part of the sort of foundational money that comes from that when the parents pass away. But as each of the next generation also pass away, their money goes into that group of people and their next generation get money if they also are insured.
Oh, okay.
So no one can get money in that particular trust unless they also have an insurance policy to which the trust is the beneficiary of it.
Any tax implications with doing this with a trust?
Well, insurance policies in general
Or not?
yeah.
Okay, I know the proceeds from a death benefit aren't taxable, but does it change the dynamic of the structure if the trust is the beneficiary?
Not necessarily.
Okay.
Because ultimately the trust is a disregarded entity a lot of times. So when the trust does the bookkeeping, as it does distributions to the family members, then it's going to list out the different family members that are going to receive that. So the trust itself doesn't receive the tax. So the beneficiaries are going to get their distributions, and that'll be there are schedules that list that, but it doesn't necessarily cause them a taxable event in every case.
Okay. And what are you seeing out there in your practice that's more prevalent and people are really clamoring for? I know last time we spoke, you mentioned that you were playing with a couple of different types of trusts. You have the overall trust, but then you're working on a more simplified trust for people who don't have that many assets, or they don't have businesses or real estate to throw in it, just a house, so to speak, that they want to make sure that they worked for, they paid for it, and they want to make sure that their child gets it.
That definitely is one that I'm working on that makes it simplified so that we have clients that can come in, pay a much lower fee than our full-blown custom trust clients. And it's a very simple trust that just says your children will receive your assets in equal shares, however many children you have, and we'll transfer your home into that trust. And it makes it very simple so that they don't have, it's not going to have things like the dynasty trust that I was talking about, where there are a lot of moving parts. There are a lot of requirements and complications and things if you do this and if you don't do that.
Yeah.
I mean, it really was very, very, very specific. But it was good because this was a family that worked very hard. They have a lot of things that they want to pass down to their family members, but they're not giving a handout. And that was very important to them, that they're not just enabling this next generation to do nothing with the money. There are very important requirements that if you're going to accept the money, there are obligations to do something with it.
Okay.
And that's why they wanted it to be, this long, multi-generational situation. But there are also business trusts that if you're going to go into a business venture with multiple people, sometimes you might not want to be in business with your business partner's spouse. So if your business partner passes away, you may go, my business partner doesn't know anything about music production, movie production. They would come in and ruin the whole thing.
Okay.
That we just build in a buyout of their share that is managed by having insurance inside of that trust.
It's interesting because what I do a lot of times with businesses is called a buy-sell agreement, whereas you take out insurance on the business owners, and if something, God forbid, would happen to them, you use the proceeds to pay off the spouse or the beneficiaries of that person. Now, would that buy-sell agreement go in the trust also? Or will that just be between the business owners themselves?
The buy-sell agreement is part of the business for the operations, but when you establish a business trust, that's sort of the entry into creating the first part of creating the business. The buy-sell is where, okay, if we're going to be sharing information, because when you set up a business trust, at least how I set them up, I like to set them up with a group of original owners, and there will be issued shares, very similar to like a corporation. They can assign those shares to another entity. So what they'll usually do is they'll assign their business shares to a holding company. And then the holding company is going to hold those shares. So your trust still owns those assets. The holding company owns what we call beneficial interest. So the holding company gets to use those assets. They get to lease the assets. They get to do all kinds of things with them that makes money, but that doesn't mean that they can transfer them.
Oh, okay.
So then you might have a holding business, a holding company for your things that you're going to be doing. I might have my own holding company, but because of how those work, we might need to have a buy-sell agreement that if our holding companies do things together, they need to be able to buy each other out.
Okay.
So it's really depends. Every business is going to be different. But business trusts a lot of times are very helpful for things like family farms. A lot of times when you have a main family business that you want one person to be able to say, all right, I don't want this thing falling apart just because I pass away.
Okay.
And someone else has got ownership rights.
Okay.
If someone else might have ownership rights to it. And because of that, their spouse is going to come in and just say, liquidate the whole thing. That means people lose their jobs.
Yes.
That means that creditors that we might have structured lending and things like that, we're forced to liquidate sooner than we planned to. And it makes everything, makes you have less money when you come out of the business just because someone passed away.
So it's really interesting going through all this because from what I'm hearing, is that there are so many different ways, one, to protect yourself, one's assets that they work so hard to build from an individual, high net worth, even a business perspective. I often talk to people different, and I always say I'll help anybody if they're making $5 to $5 million. Right. And I always want to reiterate to people that it's not about how much money you make, it's about what you do with the money you have. And if you work so hard to build something, if you work so hard to create something for your family, any type of legacy, whatever that may be, it could be a house, it could be a business, you want to make sure you're protected. I've come across so many people who aren't protected, who have businesses. And it's amazing to me how people don't realize how important it is to have this set up because in essence, you are buffering yourself, so to speak, from a lot of liability in your kids and your family and even your legacy.
Oh, yeah.
So I'm happy we're having this conversation to help enlighten people and let them know that, listen, this is important. Even if you just have a house.
Oh, yeah.
That house, you worked hard for that house. Protect it. And also helping people understand that you got to sacrifice, meaning that if it costs X amount of dollars, do it one time and it's done.
Yeah. Yeah. And when you have set up a trust, there's not a lot of maintenance that happens. If it's just a personal revocable trust, once you set it up, you don't file taxes for it unless it's going to earn money on its own. You essentially just set it and forget it. It's there, and if you want to modify it and update it, you can. But you can always go back to your attorney and say, can we just do a review and see if anything's changed? If you have a major life event, you want to look into it and say, does this modify or update or change my situation? and then revisit it and then make some changes if you need to. But, there are so many probate cases that last years because there are orphan businesses. Because dad started the business. Dad's the managing member of the LLC. Well, dad disappeared because dad died. There was never an operating agreement. There are so many people, they'll go on to the Georgia Secretary of State and they'll set up a business, but there's no operating agreement. There's nothing that dictates what happens when this person passes away. Who has the right to run the business? There's nobody. And meanwhile, wife goes to the bank and says, I need money out of this account. I need to run payroll because all these people were working all the way up until the day that my husband died. We can't let you into that bank account. You are not authorized. And meanwhile, the employees who've worked, they can't get paid. The vendors who are expecting to get paid, they can't get paid. The clients and customers that are there to buy milk, whatever, convenience store, they can't do what they need to do. And everything grinds to a halt while it waits for probate. And there are waiting periods.
Got you. And the thing is with the trust, it goes right past probate.
It doesn't ever touch probate. And you can make the trust the managing member. The trustee can
That's
be
what I wanted
the
to ask you
managing
about
member of
that.
an LLC. Yes,
Oh,
absolutely.
okay.
So then that way, if you and your wife, let's say you owned a convenience store, and you made your trust, the two of you as joint trustees, the managing members of your LLC, which is the name of your convenience store. If something happened to you, and we don't even have to kill you off, if you just lost capacity.
Okay.
And that's another big thing about
I want to
having
touch
a
upon
trust.
that. Yeah.
We'll get into that at some point because that's a whole other can of worms. But if something happened and you lost capacity, even if temporarily, you had a major medical event and she needed to step in and do things, even though you maybe ran it from day to day and she had her other job, she can step in and do things because she's the other trustee. There's no other authority she needs. It's all within the trust document. So she can come in, she can ask the manager of the store, how did my husband do this? Okay, proceed, do the things you need to do. Well, I didn't have signing authority at the bank. All right, let's go to the bank. I'm going to set that up, or I'll oversee it. I'll make sure all the employees get paid. I'll make sure the vendors get paid. I'll make sure business runs as needed. And then when my husband's better, things will get right back to normal.
Excellent. And that's because is that because the business is owned by the trust, or is it okay?
Correct.
And the trust is a managing partner, so to speak, of the business also. And that being said, since the husband and wife are part of the trust, she also has equal authorization that her husband did.
Whether he's live, incapacitated, or deceased.
Okay.
Depending on how essentially how you set it up.
Oh, okay.
And because if you do it as an LLC, because the owners of an LLC, that's the whole point of setting up a limited liability company, the owners of that LLC are shielded. What the LLC owns, what the owners of the LLC own, can't be reached by the wrongdoings of the LLC. So if something happened at a gas station and there was an incident and someone got hurt, slip and fall or whatever, they might be able to sue the gas station or the convenience store and get the assets that are owned by the convenience store. But they cannot get your personal home or the things that are owned by the trust. And they certainly can't get things that are owned by the trustees separate from that because trustees are indemnified also. So there's layers that you can even create that make it completely separated from the activities of the convenience store. And if you ever know anything about convenience stores, they don't ever own all of it in one business. The dirt's owned by one company. The gas distribution's owned by another company. The convenience store is owned by another company. There's a rental company that rents the store and the dirt to the guy that owns the business itself. So they create multiple layers. And the reason for that is if they slip inside the store, that's not going to affect their gas distribution company.
Got you.
So they even smart ones create multiple layers.
And that's what the trust does.
That's just business.
Yeah, I'm just about in general, the trust creates multiple layers. So you are almost, it's a separation between you and liability, so to speak.
Right.
Okay. And that even goes back to, say, families, that goes back to businesses, that goes to really anybody who has anything they actually want to control, so to speak, from the grave.
Oh, yeah.
And make sure that it goes to their child. Because I have a client I'm working with right now, and she bought a house. She owns a house. She's a young lady. She has a son, and she asked me about it, and I said, well, of course, talk to Attorney Green, and she said, well, I only have a house. I said, yeah, but you want to make sure
You own a house. I mean,
you own
not
a house.
only.
Yeah, a lot of people don't. A lot of people don't have a house at your age, so you want to make sure that you are protecting what you have worked so hard to get. And that's my.
Is she married or not?
She's not married.
Oh yeah,
So,
that's big.
Yes, to make sure, because we've worked with people who've went through probate, and I don't think people understand how lengthy and expensive probate is, and how much it actually drains the estate when you don't have a trust. Because I didn't know up until recently that you can really dispute a will.
Oh yeah.
Like, people come out of nowhere and say, well, wait a minute, you promised me this, that will is not correct, or that was my long lost father
They
or brother.
told me on their deathbed I would have the thing, and the thing doesn't even exist, but they will hold everything up.
Yeah, and it goes through probate, and it eats up the estate, and then guess what? After, say, 3 or 4 years, you may be out $20,000-$30,000 from your estate.
Or that asset got held up so long that the tax man got it because the taxes never got paid. Ooh. And no one knew to petition the court to get a temporary administrator of the estate. And it just sat, and the judge isn't going to do anything. It's not their job. So they sit and bicker back and forth. And meanwhile, the house is just sitting there and nobody's paying the taxes or the mortgage. And then the bank is going to come in. They're going to buy it for what it's owed. And maybe someone will bid against the bank and buy it for more. But then the only thing the family's going to get is whatever it was bid over what the bank owed at the tax sale. Wow. Or the foreclosure sale, if it's foreclosed.
Wow.
So they didn't get a chance to go in, clean it up, make it look pretty, and sell it for market rates. That's courthouse step rates.
Yep.
And so there it goes. But your client who has just the child and she's not married, what would happen if the child's a minor when she passes away? It's even worse, because let's say that house is $200,000 house. When that child is essentially orphaned, someone's going to have to step forward to become the child's guardian.
Okay.
So there's one legal proceeding. That's probably about $2,000-$3,000 maybe. But the problem is they'll have to probate her estate, even if she doesn't have a will. She has an estate plan. It's called intestate. So her son or daughter will get all of that. The issue is when a child receives an asset that's valued $25,000 or more, they have to have a conservator appointed for them.
Oh, wow.
Now, you want to talk about expense. So now you have to petition for guardianship and conservatorship of that child for whoever she might have named, if she named anybody.
Okay.
If she didn't name somebody, auntie this and uncle that and grandma here and grandpa there, they all fight. Or maybe they don't fight over the child. Worst case scenario, there's nobody for the child. Then that's a tragedy. Then the county has a conservator that they step in and they bleed it dry. But let's say there is a family member, they step in, where are they going to get the money for that? They'll have to front their own money to petition the court to get into her bank accounts or get into her assets if she didn't name a beneficiary. If she named a beneficiary and it's the child, you're still in that kind of round robin thing where if it's more than $25,000 in her bank account or her retirement or whatever that she gave to the child, you still have to go get a conservatorship, which means you have to go through the whole court proceeding.
Oh, wow.
So you have to pay a lawyer. You don't have to pay a lawyer, but you're best served by doing that, or else you're going to be very frustrated.
Got it.
Conservatorships in this state require that all conservators receive a bond. So you have to be bonded. So what is a bond? It's an insurance policy. So you go to your local, State Farm, Allstate, whichever, if they offer fiduciary bonds. So then you say, the court will tell you, well, this child has a house that's worth $250,000. Mom had a 401k that had $150,000 and other cash assets. So the child has $500,000 worth of assets that the child's going to sit on until they turn 18. Let's say the child's only 3 years old. That's 15 years. That bond is due every year. The cost of the bond is related to the value of the estate. So I had a case probably 4 or 5 years ago child received $250,000. The bond was $1,300 a year. And he was 2.5.
Oh, wow.
So, I mean, every year it became a drain on this child's estate that his parents
It's amazing.
left for him.
Well,
So, no,
it's
the investments wouldn't be able to keep up if it was a bad year.
Yeah.
And if it's real estate, sometimes the market just isn't going to grow that fast.
Exactly.
And the guardian may not want to live in the home that the parents left for the child.
Exactly.
So they may say, well, we don't want to be real estate agents, or we don't want to be landlords. They might ask the court to sell it, and the child has no choice. They're too young
To sell it. Wow.
to object to them selling mom and dad his or her childhood home.
Well,
But if there's a trust and a trustee and there's insurance that goes to the trust that says, no, pay off the house, put a renter in there, whatever, save the house goes to the child, there's no court that can tell them otherwise.
wow.
Because it stays out of probate.
Wow. Well, I mean, this is a lot to take in. And what we're gonna do, because I want to continue talking to you about this, we're gonna take a short break, come back and reiterate what you've said and circle back on a couple of things I want to talk to you about when you talked about if your spouse or parents become incapacitated, why that's so important.
Oh, yeah.
So, but anyway, again, we'll be right back